Honorable members, we will now move to the Anti-Money Laundering and Countering the Financing of Terrorism Amendment Bill 2023, Bill number 13 of 2023, published on the 20th of July 2023. Honorable members, Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlall.
Thank you, Mr. Speaker. Mr. Speaker, we have come now to the final item on our agenda, and it is the third of the three bills in relation to our A.M.L.C.F.T obligations. Mr. Speaker, those of us who are familiar with this sector would know that over a period of time, every territory in the world would be required to update their legislation by amendments. That is the principal legislation. These amendments are required because at the international level, at the level of the regulatory bodies, directions and recommendations are promulgated to be implemented by regional regulators. And these directions and these recommendations are conceived and crafted based upon experts and examination of international trends in the area of A.M.L.C.F.T and terrorist financing. As the landscape of these offenses change, as they become more complex, as they become more sophisticated, as they become more prevalent, as they change their character, so will the recommendations that will come to meet the changes and exigencies of what is obviously an evolving phenomenon. So, at periodic intervals, we are required to update our A.M.L.C.F.T principal law to capture the latest compendium of directions and recommendations from these regulatory bodies. So that is the first aspect that the bill deals with. The second component of the bill addresses certain weaknesses, many that arose out of amendments that were made while we were in the opposition and while the coalition was in government. Those who are following this A.M.L.C.F.T law will know that when we were in government as a minority government, many of the important and crucial bills requisite for this sector were voted down by the then joint opposition using their one-seat majority. And that attracted certain sanctions and caused devastating consequences in our financial sector, which in turn affected the livelihood and lives of every single Guyanese. When there was a majority government after the 2015 elections, there was great haste to pass all those bills that were voted down and to implement an already backlog of accumulated regulations and directions that came from the international agencies. So a whole suite of bills were brought by my predecessor, Basil Williams. When they were being promulgated, I repeatedly made the criticism that what I am seeing in the bills were the raw importation of the recommendations without filter, without adjustments to make them conducive and pliant and relevant to a Guyana context. These recommendations are coming from first world countries. You have to examine them, you have to filter them, you have to adjust them, you have to bring them in conformity with your constitution if you have a constitution that is supreme, and you have to adjust it to meet your societal needs. Though they are international regulations and you are not permitted to alter their core, you can alter them to bring them in conformity with your law. That is what sovereignty entails, right? Yes, I'm glad you appreciate one concept tonight. So what was being done during that time was a whole host of wholesale implementation of raw recommendations. So you have a whole host of provisions in our laws that are over onerous for Guyana. What countries in the Caribbean have been forced to do, and third world countries in particular, where you don't have a real terrorism threat? Let us don't kid ourselves. We don't have real terrorism here and real terrorism financing going on in St. Lucia and Antigua. People can barely keep the economy afloat. So you have to work on these recommendations when they come, or else this one sector getting compliance can bankrupt your country. That filter was not done. So we have a whole set of perverse set of provisions in our law, and then some of them, I believe, were strangely altered by my predecessor to give the Attorney General certain extraordinary powers, one of which I will highlight later. So another component of the bill is to correct some of those deficiencies. And that is a work in progress because there was so much that were done. The third component deals with addressing identified deficiencies in our existing laws. Some of them are deficiencies dating back years, and some are part of the new recommendations that have come. And when you apply them to our legislative landscape, you realize that because of those new recommendations, our legislative landscape now becomes inadequate in order to implement those new recommendations. So the third component that this bill encompasses is a bringing together of a compendium of amendments that are designed to correct the deficiencies in our legislation. In particular, to strengthen our forfeiture capabilities. It is recognized globally that one of the most important components of the fight against money laundering and financing of terrorism and organized crime generally is to hit the criminal in the pocket, hit him where the property is, go after the proceeds of the crime and forfeit it. And by that, you can dismantle the criminal empire or enterprise, as the case may be. The third aspect of this amendment is directed in that arena to strengthen our forfeiture laws. Mr. Speaker, I have spoken at length about the impending assessment that we are going to be subject to in September. And this is a bill that is intended to ready Guyana for that assessment. Mr. Speaker, the instructions that would have informed the drafting of this bill also came from a national risk assessment which was done of Guyana's financial system. And in that risk assessment, our financial sector was forensically examined from the perspective of A.M.L.C.F.T compliance regime. And a number of deficiencies and or recommendations came out of that. And we had to put that in a report as part of an action plan, that these are the actions, administrative and legislative, that Guyana will implement to address the risk and the deficiency highlighted in the National Risk Assessment. So we prepared a national action plan, and in that national action plan, we outline what Guyana plan is in terms of A.M.L.C.F.T for 2023 or 2022, I think, till up to 2025. We are also, by this bill, implementing that national assessment, that national action plan. When the assessment begins now, it is all, apart from going on-site visits to the various reporting entities, supervising authorities, etc., and look at their administrative functioning, look at their record keeping, look at their personnel and their capacity, they will also be examining our framework, our administrative framework on paper, as well as our legislative framework. So if we said in that action plan that by that date we will be ready with legislation, we have to be ready with the legislation. So, Honorable Member Mr. Ramjatan, I'll just give you another explanation which impinges on the tedious requirement of the enactment of these bills before that impending exercise. In terms of updating, we have, as we passed a bill here, another step in the action plan to amend our law to allow Guyana to join the Egmont Group. I am pleased to announce that we have been sponsored and we will be formally admitted into Egmont membership early in 2024. That will allow us now to be part of that part of the world where we can share information, we can do all types of collaborative arrangements in relation to A.M.L.C.F.T. We were one of the last countries in the Caribbean. The reason all of that part of our obligations were held back, it is because of the 3 years that you voted down the A.M.L.C.F.T. bills. You see why we needed to accelerate now? You are hollering just now and screaming about time. It is because you have put us at a great disadvantage for a period of 3 years when the rest of the Caribbean was galloping forward in discharging their obligations. We were the pariah and the black sheep of the Caribbean, thanks to you and your coalition partners. Mr. Speaker, we have also received help in crafting these arrangements from the World Bank. They came and they did some assessment of our financial sector, and they have also offered guidance to us. Outside of the A.M.L.C.F.T framework, we are required to sign what is called an interagency arrangement that will establish a collaborative framework for the A.M.L.C.F.T sector in Guyana to collaborate with other players that are not yet in the sector. The Wildlife Commission, the Diesel Commercial Registry Authority, the Guyana Defense Force, the Coast Guard, they are not A.M.L.C.F.T type institutions. But the requirement is that we must have a framework of cooperation with them so that information can be exchanged between these agencies. Mr. Speaker, the design of this bill and these regulations came as a collaborative effort of our A.M.L.C.F.T National Coordination Committee, which include competent authorities such as the Financial Intelligence Unit, Attorney General Chambers, Guyana Securities Council, Guyana Geology and Mines Commission, Guyana Gold Board, the Guyana Gaming Authority, the Bank of Guyana, as well as the Special Organized Crime Unit and the Office of the Director of Public Prosecutions. I pause here, Mr. Ramjatan, to tell you that all these agencies that I've just mentioned, they are all supervisory authorities, and they have all the powers that we have given that commission. And they have had those powers since 2009, and Guyana did not come to an end. So all the screaming and fussing and kicking and biting that you are exhibiting there were totally in vain, but perhaps for the camera. We also have had a timely reviews by international partners such as the IMF, World Bank, as I have said just now, the National Center for State Courts of the United States of America, and the United Nations Office on Drugs and Crimes, who have also provided critical input and guidance towards ensuring these legislative provisions meet most up-to-date standards of FATF recommendations as they stand presently. That's the kind of work that went into these bills for the benefit of Guyana. You don't have the time to even read it, but you come here to cuss it down. In the interpretation section, definitions have been upgraded in a number of areas, such as politically exposed persons. And listen to this. You see how you're excited? You haven't read it again. Politically exposed persons. As required by FATF recommendation, a PEP will now include chief executive officers, directors, and senior officers of international organizations. So international organizations operating in Guyana now will be considered, are to be considered by FATF recommendation, not us. So you can go on the platform and say, PPP is control freakism. Now we want to control the CEO of the international organizations. It's not us. And that's why I wrote it that way. The Financial Action Task Force international recommendations to all countries in this hemisphere is to include in their PEP lineup these CEOs for international organizations. Further, our legislation had a number of deficiencies in relation to what is required for the designation of persons domestically or by the United Nations Security Council resolutions, UNCSR. So you ought to know that categorization. You are a former Minister of Home Affairs. These updates to the legislation have now clearly determined a method that has a clear identifying mechanism. As a result, where the director of the FIU on reasonable grounds suspects a person or entity to be involved in terrorist or proliferation of weapon of mass destruction activities, including terrorism and proliferation financing, or the person is part of a UNSR list, or if a country makes a request to designate that person, the director will make that recommendation to the Minister of Finance, who will make a prompt determination. Again, you might want to feel that the Minister of Finance wants this power to make a determination and to designate a person a terrorist. Again, we are implementing and codifying an international direction. If we don't do it, we can be sanctioned. Notices, all actions are required to be done without delay and without notice to the person or entity involved. You hear that? When you're designating the man, you don't have to tell him, Anil Nandlall didn't write this, the PPP didn't write this, the FATF people, the great Democrats of this world, say, but you must not give them notice. The FATF, as you would affectionately refer to them. All action are without delay, without notice to the person or entity involved. In order to ensure that freezing mechanism is immediate, listen to this, the DPP is required to apply to the court for a freezing order against any assets of such persons or entity or accomplice or person acting on their behalf, which shall be granted by the court. I don't know how the court will deal with that. That is the direction. The DPP is to make the application immediately, ex parte. Ex parte. Don't have to go through piece. You need to understand it. Notices and updates are to be provided to reporting entities. The reporting entities. You see the mechanism now? Who are upon discovering that they may be dealing with assets of a listed or designated person or entity, are required to immediately freeze the assets and make a report to the director of the FIU, and if determined to be so, will request of the DPP to apply for a freezing order. So when the accountant now realize that they are doing work for a man listed by the UN as a criminal, they are now required to make a report. And if they have in their hands or in their custody documents relating to assets that are implicated in that wrongdoing, that international crime, they are to report it. What is wrong with that? What is wrong with that? Accountants want to be part of a criminal enterprise? Lawyers want to be part of a criminal enterprise? Well, that is what the bill does. That is what that compliance bill does, to bring them in that framework. Is either you want to live in a lawless society or you want to live in a regulated, lawful society. Guyana has already, I forgot this part. Guyana has experience in this area, Mr. Speaker, having performed a designation based on a request by Trinidad and Tobago in 2017. Who was the government in 2017? APNU, AFC. The person to whom I am referring are Abdul Kadir, that name's ring a bell, aka Aubrey Michael Seaforth, a former member of this parliament, and Abdel Noor, also called Compton Eversley. The order to designate Kadir and Noor was signed by then Junior Minister Jaipal Sharma and was published in the official Gazette on Wednesday, 30th of August 2017. And then, actually, honorable member, you recall, just a couple of months after, they held a special sitting of the parliament and moved a motion to honor a man, Kadir, that they designated a terrorist. You designated the gentleman a terrorist, your Minister of Finance, under the legislation. And then, Lanchan is a great man, deserving of all the accolades.
Oh yeah.
All the accolades that we can give him.
Oh yeah.
You compare Lanchan with Kadir? Oh my. I will ignore you for the rest of the night. Mechanisms for unfreezing have also been included to ensure equity and fairness in relation to if such a person dies or no longer meets the criteria. We have also ensured that where the legislation allows for a listed or designated person or entity to request funds, such as for living expenses and court costs, that person applies to the court for such an order. And this is what I was speaking about. This power was originally inexplicably given to the Attorney General by my predecessor.
Control freakism.
You're talking about control freakism? I am now putting him back to its rightful place.
Like a mouse then. He said you have to tell back to
When you designate a person and you lock him up, you now have to allow him access to his funds to get lawyers. The current law is that you got to make an application to the Attorney General to get that money. Me, I am, by this amendment, putting it to the court, the rightful place. I have no business in presiding over other people's money, and you accusing us on this side of control freakism. And you accuse your predecessor, AG, as being ultimately familiar. Madness he did. No part of the Caribbean has that perversion and perversity. Remember Comrade Gale? We argued, we objected to it vehemently. On what basis would a member of the executive wield that power over people's personal property? If we were control freakists, my friend, or whatever it is you're calling us, we would have kept this power. You give it to us. And we could have been wielding that power. You see how nonsensical your allegations are? We did not see it fit or proper for the executive to have the power to make that determination. The court is the authority to grant such orders. And as a result, that power should remain with the court. This is the position with all the jurisdictions in the Caribbean. And we are putting it to its rightful place now. In cases where bona fide third parties are affected, the bill allows for specific provisions to be made to protect the interests of third parties. So if third parties are implicated innocently with properties that are tainted, they have protection under the bill. So you can innocently, or anyone can innocently go and pay down on a house, not knowing where the owner got it from or by what proceeds the owner may have used to acquire it in the first place. But you have gone into an agreement to sale, paid down a substantial sum of money, and now the state authorities come and determine that that is a property tainted or purchased with the proceeds of crime. This bill protects third-party interests insofar as you are a bona fide purchaser for value without notice of the wrongdoing. There is an amendment to Clause 15, which now provides that a reporting entity will not perform consumer due diligence if it is likely to tip off a person, and that reporting entity will submit a suspicious transaction report in lieu of conducting that type of engagement. So here it is that you don't want to alert the person. Ordinarily, you are to report certain things, or you conduct what is called a customer due diligence test. But if you suspect right away, then you go to the suspicious transaction route. You don't tell the man anything, and you activate the whole process. That will begin an investigation. Mr. Speaker, reporting entities under the A.M.L.C.F.T. does not only encompass financial institutions such as commercial banks. Reporting entities also include designated non-financial business professionals such as dealers in precious metals and precious stones, real estate agents, auto dealers, casino operators. As I said earlier, lawyers and accountants are now part of that repertoire. Further, it also encompasses, I just said that, attorneys at law, notaries, accountants, trust and company service providers. in specific instances, such as transactions involving sale of land, managing of clients' monies, etc. And let me make this point. I now realize that Mr. Ramjatan was speaking, as his colleague were, on a bill that he did not read. So, Mr. Ramjatan, is not all aspect of the lawyer's conduct is under review or will be part of this monitoring, or the accountant. There's a schedule in the bill that tells you what type of transactions. So the lawyer doing a divorce, or the lawyer doing, it's only when you deal with property, conveyancing, trusts, company business. Only then you have that relationship. You see, you didn't read the bill. And that's the point I'm making all the time. You don't even know that the schedule exists and the list of duties, list of activities that are subject to scrutiny and therefore what are not. In light of the new international thrust with regard to beneficial ownership, the amendments require reporting entities to understand the nature of the customer's business and its ownership and control structure, particularly if the customer is a body corporate, legal person, or what the directions describe as a legal arrangement. As required for better supervision governance, supervisory authorities such as the Bank of Guyana can impose administrative pecuniary penalty regimes for supervisors for those breaches which may not merit the situation of going before a criminal law-based tribunal, but to be dealt with by the supervisor in addition to their powers of sanctions. As a result, the supervisory authority may suspend, cancel, or revoke any permit, registration, licensing, or any other authorization it has issued, or to take any other administrative penalty. You hear that? It's the same thing in the compliance bill. It's the same thing. This one here now is an update of those. This one, what we just did, is the modern expression of it. We are now updating those to bring them in line with a new set of recommendations and responsibilities. Mr. Speaker, Guyana is aware that it needs more modern updates to its confiscation and asset recovery regime. I spoke about forfeiture earlier, and this is how the bill treats with it. We have had visits to the country by the National State Courts and the Regional Security System Asset Recovery Unit, who have also not only illustrated where we can improve in terms of a country report, but also provided a model law which we have extracted and used to bolster this regime. Honorable Member Annette Ferguson, for your information, we have used a model law prepared by the Regional Security Service Asset Recovery Unit. So when you read it, and if you're going to read their law, you might now again jump to the conclusion that there is plagiarism. It is borrowing. They have gifted this to us, and we used it. Harmonizing. You have lucid intervals sometimes, Mr. Ramjatan. As a result, this bill will now ensure that applications for law enforcement orders under this act can be made to a magistrate or a judge. Search warrants may also now be granted by a justice of peace in order to facilitate hot pursuit, tip situations to enable swift actions and prevent a person from quickly dissipating their assets that are proceeds of crime or instrumentalities of the crime. Now, don't get all excited. You know that JP has been exercising this power 100 years now in ordinary criminal law, issuing warrants. We are extending the A.M.L.C.F.T. powers now to issue warrant in those legislation to the JP. They have it under the Criminal Law Offences Act. Next thing you wake up tomorrow, you discover this, and you jump on top of the wall and start to scream down. With regard to restraint orders, new additions to the bill by amendment to Clause 39 ensure that Not only can the court make whatever orders it deems necessary in order to make restraint orders effective, but also enable law enforcement officers to seize the property for the purpose of preventing any property being removed from Guyana or concealed or destroyed. So obviously, if the criminal is about to transfer his assets, to dissipate his assets, you have a power to go to a judge and get an order to restrain that. And those are powers that judges exercise all the time.
Tell them.
An amendment to Clause 44 of the bill also allows persons with an interest to apply for revocation or dismissal of a restraint order, including persons who are bona fide or innocent third parties. The court can also provide variation of such orders. Obviously, most of these orders are going to be made ex parte, because of hot pursuit type of arrangement or situations, or even if they're made inter partes, orders of court are always subject to variation. Due process is going to be extended. These are judges of the High Court. They are bound to extend these facilities. Third parties can go and establish that they are innocent and their properties are innocently impugned, and they can get their properties extricated and exonerated from criminal stigma and process. This bill inserts a new clause 45A, which is taken from the Regional Security System Asset Recovery Unit Model Proceeds of Crime Bill, which does not exclude hearsay in matters relating to restraint orders. It indicates that it may be used as evidence and does not fetter judicial authority to consider it. So hearsay now are accepted in applications made for these orders, because a lot of time you have to rely on hearsay information. You don't have direct evidence. The bill also inserts a new clause 57A, 57B, 60A, 60B, 60C, and 60D. These additions are from the Regional Security System Asset Recovery Unit Model Proceeds Bill, and provides for the following. Clause 57A provides for the court to determine any question arising under Clause 54 or 57, which deals with confiscation, pecuniary, and penalty orders on a balance of probabilities, thus indicating a more reasonable threshold than required on a reasonable doubt basis as applied to criminal proceedings. So here, the whole onus, burden of proof is now changed, and it is now, for these applications, these forfeiture proceedings, is on a balance of probability, a lower burden, and not on a reasonable suspicion level of proof. That obviously makes it appreciably easier for an application to be successful. The court shall determine any question. The court can order a defendant to provide information, and if they refuse, the court may draw inference from such. I pause. When you are requested to supply information, you have to comply. If you fail, the court can now draw an inference. So your right to silence is no longer intact as it used to be. The court, as in England, can draw inferences, adverse inferences, if you remain silent. This is in order to facilitate such matters without affecting the issue of the trial at large. If, as subsection 8 indicates, that no information given under this section which amounts to an admission by the... This is in order to facilitate such matters without affecting the issue of a fair trial, if any. As subsection 8 indicates that no information given under this section which amounts to an admission by the defendant that he or she has benefited from criminal conduct is admissible in evidence in proceedings for an offense. And this is a very important safeguard. Here in these applications, even if you incriminate yourself for the purpose of forfeiture or restraining your assets, that incrimination will not be used in your trial for the conviction. And I believe that is a remarkable little innovation by the policymakers to ensure that they go, it's better you walk. That's what they're telling you here. It's better he walks free, but we get all the assets and the proceeds of the crime. So the bias is right here being exemplified. Clauses 60A, 60B, 60C, and 60D sets out an elaborate regime in respect of how payment is to be made under a confiscation order. Now, one of the big problems with our law is that there is a power to make a confiscation order, but there is no subsequent power to ensure that the order is complied with. That is now being corrected. 60A mandates full payment on the date that the order is made. However, if the court is satisfied that the defendant is unable to pay the full amount on that day, it may order a payment scheme for the payment which must not exceed 3 months. So the criminal here, once the asset is implicated, once the monies are implicated, once there is a finding that reparation has to be done, then payment is swift. It's not going to fall through the crack as the current system allows. Within 3 months, there must be full payment. There is a power to extend that 3 months to 6 months. 6 months. But a case has to be made out for same to be done, and the director of public prosecutions or the relevant competent authority must be allowed to make representation if such an extension is sought. There's still another 3 months, but after that, it's finished. So maximum 6 months. But to get that other 3 months is quite an onerous task. The director of public prosecution has to be informed, or the relevant authority, if it is SOCU, if it is the police force, etc., or Geology and Mines Commission, Gold Board, they are all empowered with these powers. 60B charges interests on all monies to be paid. So if you want an extension of time, there is an interest provision, and your staggered payment will now attract interest. 60C converts these sums ordered to be paid to have the effect of a fine imposed on the defendant by the court. The court is empowered, if there is a default in payment, to impose a term of imprisonment no less than 10 years. So, if these orders are made and they are not paid, then they will be converted into fines. Now, when the fines are not paid, that's not the end of the matter. 10-year jail, or no less than 10-year jail. Many times you read in the newspapers that the person is found guilty for X amount of cocaine, he's fined millions of dollars and sentenced to 3 years in prison. He goes to prison, he never pays that fine. He never pays that fine. Now, you can go after his property for that fine, for that money. If he doesn't have that money, that fine itself, he goes to jail for not paying. So in addition to the 3 year, he will now, if he doesn't pay that huge monetary fine, he now has to go to another term of imprisonment for no less than 10 years. 60D applies these forfeiture powers to monies held by a third party or held in an account with a financial institution. So naturally, these powers will extend to monies in banks or monies held for the implicated person by a third party. Clause 66 of the bill has been substituted as it previously precluded assets gained before the passage of the Act from confiscation. The new provision substitutes that provision with one that now provides the opportunity for the relevant competent authorities to go after any assets suspected to be tainted property or having been assessed as proceeds of crime. So, the current legislation prevented one from going back to look at properties acquired before the criminal conduct that is under investigation. This bill removes that fetter. And any property, once it can be linked, well, whatever date it was acquired, once it can be linked to criminal conduct or the proceeds of crime, it is now the subject of forfeiture. The new clause 66B to 66E deals with the creation of a national forfeiture fund, where the value of the items all forfeited shall be placed in this fund and used for the benefit of fighting A.M.L.C.F.T and its predicate offenses. So, it is the criminal monies, the criminal properties, the criminal proceeds that will now be confiscated, put into a fund, and used to declare war on the criminals. So their own assets will be used now to deal with them in investigation, etc. Clause 68 has been amended to provide more clarity. Therefore, it not only refers to funds, but also other properties and assets which provide the widest range possible. Further, it ensures that terrorist acts, regardless of whether the person alleged to have committed the offense is in the same country or different country from the one in which the terrorist or terrorist organization is located, or that terrorist act occurred or may occur, are recognized and can attract sanctions. Mr. Speaker, the bill also speaks in greater details to some new powers of seizure and detention that are conferred. As I said, these are all powers which we are extrapolating from the regional security systems model legislation.
Honorable Attorney General, you're 2 minutes over the 45. You'll need an extension.
An extension.
Mr. Speaker, I'd like to ask that the honourable member be given a few minutes to conclude.
Honorable AG, you may continue.
Yes. And there are some new offenses that are created in relation to the proliferation of financing, etc. I don't need to go through that. I think that I have done reasonably good job in outlining the important provisions of the bill, and I've begun by also giving a general overview. So that's what the bill is really about, Mr. Speaker. Again, I emphasize as I close that it is simply an update to our A.M.L.C.F.T. Principal Act, and it is a central part or a significant part of our obligations under our international arrangements, and we are required to implement this bill with all its provisions before September, when the assessment is scheduled to take place. With those words, Mr. Speaker, I commend that the bill be ready a second time.
Wonderful, wonderful.
Thank you very much, Honorable Attorney General.